what is office they are working. So first, according to hierarchy, first we have director of labor in every state, ALC, that is additional labor commissioner, then deputy or chief labor commissioner we will have, then labor commissioner, and under this we'll have the factory inspector, or you can say assistant labor commissioner under this. Then GLO, in some case GLO will be not there, that is government labor official. And yes, last, it will be state wise, maybe different in some state. Somewhere you can find that labor of director of labor is not available. Okay, it's fine. ALC will be there. Maybe chief labor commissioner will be there. Directly factory inspector will report to the chief commissioner of labor. Yes, might be possible, right? So this is the hierarchy that every labor department in our city or area they are following. Now, under the ID Act, Industrial Dispute Act, right? What is settlement machinery under the ID Act? So we have conciliation. Generally, first it is conciliation, that then board of conciliation. Who do the conciliation? That is a factory inspector, or in some case labor commissioner or assistant labor commissioner, as per the authority. Board of conciliation or board of conciliation, whatever, that will come under the top management of labor department. They will decide. Then second step, we have court of inquiry. They will, if you are not satisfied, like you have issue with the union or union have issue with the company, there is some strike or lockout, whatever, and they are complaining to the labor commissioner and then group of the commissioner of labor and chief and whatever. And if you are not satisfied with the answer, or you are not okay, then you can go to the court of inquiry. They will refer to the court of inquiry, right? In 6 months, they will report. They will give the report. Again, if you are not okay, then voluntary arbitration is there. Both party, whether employee, employer, union, whatever, they will have the voluntary arbitration. And last, you can do the adjudication. This is the hierarchy which is under the ID Act for the settlement machinery. Whichever disputes are there under industry, whether it is for the factory, whether it is for the plant, whether it is for the shop and establishment, whatever, कहीं पे भी कोई भी इशू है एम्प्लॉई के बीच में और मे बी कंपनी और यूनियन के बीच में, in that case we will follow this hierarchy. Everybody has to. Right? Then next we have, now what are the steps that we have to follow? So first of all, an employee can directly file claim before the labor commissioner, or we can say conciliation officer, for any kind of individual dispute. Suppose company is not giving me the salary, or not giving me the bonus, or not giving me the full and final settlement, right? Any kind of issue, or deducted some amount from the full and final settlement, not giving the salary on time. So any individual disputes is there, then you can refer to the labor commissioner. We have the right under labor law, right? Which we can say conciliation officer, first step. Okay. Again, an employee can file complaint to labor commissioner or factory inspector for non-maintenance of register, non-furnishing of returns, if you know, not displaying abstract of the act or rules in company premise, and request to conduct search. Right? If employee, as an employee, if I am working with any company, and in that case, I am finding that the company is not maintaining the register or not displaying whatever rules, like we have to follow this rule, this act is applicable, these rules are applicable, that will be in local language and one English language. And if other state employees are working, then the language also, that all rules we have to follow at notice board. But company is not doing, then we can request to the labor commissioner to conduct a search. We can file a complaint also. Right? This is our right. Now, okay, what is next step? Again, an inspector or maybe assistant labor commissioner, conciliation officer in case, may conduct inspection, that's suo motu, in his or her own accord, or upon receiving complaint from employee or direction from labor commissioner. So they have a right that they can come to your premises, company premise, and they can conduct the search. If he or she is receiving a like a complaint from the employee, or we can say directly at any direction from the labor commissioner, or again in case of any inspection audit, they can. Depending on the finding from the inspection, they can give like company to explain all the things. Yes, they will give the like notice, 30 days notice, 15 days notice. They will give some time, right? Because they are public servant, right? As we all know. So they will give some time, 7 days time, 15 days time, and give idea like you can submit this all, and yes, okay, we are okay with the document or whatever. But after that, if you are not giving explanation or not furnishing any documents or register, then they will proceed for the further. So last, if inspector or assistant labor commissioner or whatever authority are not satisfied with the particular thing, then can initiate the criminal proceeding with the sanction of the again labor commissioner wherever required for imposition of the criminal consequence for violation of the employer's obligation or non-maintenance of register or reference. First of all, they will give the notice. If you are not replying within the proper timing, then they will proceed. They have the right. As an employee, yes, I have the right. Again, they have the right. So company has to follow all. We are finding like many companies are not following the registers or not making any things. Now, what is next step? In case labor commissioner himself authorize initiation of recovery proceeding, right? If they are not paying any salary, not payment of the minimum wages, despite issuance of the order, also authorize initiation of the criminal proceeding before the magistrate of your area. So what labor commissioner will do? वो अगर मिनिमम वेजेस आप पेमेंट नहीं कर रहे हो, एटलीस्ट हमारा जो बेसिक है वो मिनिमम वेजेस इतना होना चाहिए. In that case, if you are not following and they have given the notice to you, again you have not changed your salary structure. At least you are not paying basic salary, that is minimum wage. So they will take action as per the law. Employee may collectively approach labor commissioner in his or her capacity as conciliation officer under the ID Act. In first PPT, we refer na that conciliation officer, board of conciliation, all. So as an employee, yes, I can directly go to the labor office and I can give complaint in writing with the required document. Any employee can go. And last, labor commissioner may enable them to allow the tripartite settlement. Tripartite, that means employee, company, and this labor commissioner. Agreement, or upon failure to arrive at such agreement, refer matter to the industrial tribunal or labor court. Finally, then you can go to the labor court or industrial tribunal. When we can go to the labor court and when we can go to the industrial tribunal or national tribunal, that we will refer into second session. So please wait. There are certain criteria that everybody has to follow. Right? Now, brief note on inspection. क्या है ये? An inspector duty is to conduct inspection and make sure that provision of various labor laws are being followed. Right? Every inspector of factory area or maybe labor commissioner. उनके पास right है. They can come to the all premise. They will ask for any kind of document related to labor law, like your account book or maybe payroll software or register or whatever. वो आके चेक कर सकते हैं. नहीं है तो आपको टाइम देंगे and you have to give all the document. पार्ट ऑफ द डॉक्यूमेंट मांग सकते हैं, उसका कोई कॉपी मांग सकते हैं, ओरिजिनल डॉक्यूमेंट भी मांग सकते हैं, व्हाटएवर. ओके, देन they may give defaulting organization an opportunity to rectify its action by issuing so cause notice. Sorry, आपको चांस देंगे, एक नोटिस देंगे, and sufficient time to correctly follow the rules under the various act. If they are coming for the inspection, then yes, first of all they will check. If not okay, then they will give chance to rectify it. को 7 दिन का, 10 दिन का, 15 दिन का जो भी टाइम है वो देंगे. कभी कभी 2 नोटिस भी दे, कभी 3 नोटिस भी देंगे in that case. So every company will follow the various labor law and rules also. And last, if the company fails to do, he or she may initiate the criminal proceeding against the company, right? But in this case, first need the consent of the chief labor commissioner or deputy labor commissioner or whatever as per the hierarchy. First of all, they have to take the consent before the final proceeding. They can give the notice, they can take the action, but for the criminal proceeding, hierarchy wise, they have to check. So this is about the brief note on inspection that every labor department is following, whether you are from the Maharashtra, whether you are from the Tamil Nadu, whether you are from the Karnataka, or whether from the West Bengal or Gujarat, whatever. Every state has same hierarchy. Maybe 1 or 2 will be different, but this process has to follow by the all, because this is under the ID Act that we are referring now. ID Act, that is Industrial Dispute Act. It is centralized act. So in every state, it will be the same. Now, what are the types of courts? कौन से type है court के? So first, labor commissioner court, right? By the appropriate government. Appropriate government, that is maybe central or maybe state. Conferred power under the different acts, like for gratuity, for minimum wages, for the payment of wages. Under they are controlling authority. They have given the name. For Trade Union Act, function of the registrar. ID Act, function of the conciliation officer. So they have the right. They can check and they can report to the next authority. Non-payment of the minimum wages, non-payment of salary by specified day, that is 7th or 10th as of now. Right? Non-payment of gratuity or bonus under different kind of labor laws. They are filed before the Labor Commissioner Court, that is Board of Conciliation. Right? So these are the types of courts. Yes, remaining are pending. So I can go and I can complain. Okay. Now, Labor Commissioner Court. Labor Commissioner is one who hears matters of the wages related issue, union related issue, whatever. Under ID Act, Commissioner, that is Labor Commissioner, it is conciliation officer, and who further refers this matter to the Industrial Tribunal or Labor Court if dispute does not get resolved by him or her, or they are not coming to the particular point. Suppose I have issue and I am not getting the salary on 7th or 10th. मुझे 7 और 10 को सैलरी नहीं दे रहे लोग कंपनी में. मैंने रिक्वेस्ट किया कि सैलरी टाइम पे तो 15 को दे रहे, 20 को दे रहे, 2 महीने का साथ में दे रहे. सो एक महीना मैंने वेट किया. आई एम वेटिंग लाइक ओके नेक्स्ट मंथ आई विल हैव सैलरी ऑन टाइम. अगेन कंपनी इज नॉट गिविंग. आई विल टेक द प्रूफ एंड आई विल गो टू द लेबर कमिश्नर ऑफ माय एरिया, who is conciliation officer, right? They will come, they will give notice to the company that kindly make the salary on time if any issue. tell them in advance, because employee has certain like responsibility also, right? As an employee, I have certain responsibility. So yes, again, if issue does not resolve, then they will ask to you to employee that you can go to the labor court for the further proceeding, and in some case industrial tribunal also. Hmm? And last, settlement is arrived at during the conciliation proceeding. It is known as tripartite agreement. In case I am complaining and company is there, and this labor commissioner, that is conciliation officer, is there. So 1, 2, and 3 person are there. So it is tripartite committee agreement, like agreement between employee, trade union, company, that is employer, and conciliation officer, vice versa. In that case, if it is issues resolved, then it is tripartite agreement between 3 person. It may be employee, company, conciliation officer, union, employer, and conciliation officer, whatever. Employee, union, and employer. Yes, it is also fine. In that case, that is tripartite agreement, right? Now, inspector's office under various labor law attached to the office to the labor commissioner. In same premises, they have office, right? Generally, it is labor office. In every city, mostly, or nearby your city, you can find this office. All officer, that is labor commissioner and deputy chief, all will be there, mostly. And their duty is to ensure that every company is complying with the provision. And in that case, he may or she may inspect the company's premises, issue various kinds of notice, may demand for any kind of evidence related to labor law. Inspector can conduct independent proceeding, right? But cannot impose any punishment for violation for which criminal or civil penalties are specified. Inspector can come to your company, your premises, ask for any document, right? Impose penalty, but cannot do the punishment under criminal civil penalty. They don't have the right. And last, labor commissioner, who can conduct legal proceeding, whose designation may be ALC, DLC, or joint labor commissioner as per the act. So they can proceed. And this will depend on how the appropriate government notifies the authorities. In your state, in your city, who are the first authority, who is second, who is third, and who is fourth. So this will have the right to process for the this penalties, civil, criminal, whatever. Right? Okay. Now, under the Gratuity Act, suppose if a person is aggrieved by the order of the controlling authority, generally, who is controlling authority under Gratuity Act? तो Deputy Labor Commissioner or Assistant Labor Commissioner, दोनों में से कोई भी हो सकते हैं. Such a person can file appeal to the appropriate government or authority directly. Right? मेरे पास कुछ issue है and I am going to the controlling authority under Gratuity Act. Suppose controlling authority, that is Labor Commissioner, suppose ALC. And if I am not okay with the decision, then I can go to the authority, next authority, as per the hierarchy of ID Act, as we all know. And appellate authority is within the Labor Commissioner's office itself. If first is ALC, then next one Labor Commissioner, then Deputy, then Chief, and then Director. So hierarchy wise, I can go. First is not okay, then I can go to the second, third, whatever. For example, in some state, appeal can be made to the Joint Labor Commissioner, and essentially appeal lies from the Labor Commissioner of lower rank to the higher rank, as we have. So in every state, in your city, you have hierarchy wise authority, then you can go there directly. And again, in induction part of our like joining process, we can like explain to the employee also, but no one is doing this thing. As an HR, that is our responsibility. Now, next is when labor courts or tribunals gets involved. Right? That was introduction part. What are the types of courts and all we referred. Now, when does this labor courts will come, or maybe industrial tribunal for the action? So these both are authorities under this ID Act. Both are separate, right? Labor court and industrial tribunal, both are the separate entity. But both will be situated in the same premises, mostly in physical premises. There will be one building, or you can say office, and there will be a labor court in particular area, and same into the particular area means premise. In some office there will be a labor court, and some there will be a industrial tribunal. Again, industrial tribunal has no power to impose any kind of criminal punishment. ठीक है, कोई criminal issue हुआ मतलब, तो in that case उसके पास कुछ power नहीं है ट्रिब्यूनल के पास, right? If the conciliation proceeding fails, which conciliation? That as per the labor commissioner. अगर उसके पास हम लोग गए labor commissioner के पास, in that case he or she is not helping, or I am not okay with the decision, then conciliation officer refers to the labor court or industrial tribunal. A direct reference may also made by the appropriate government to the labor court or industrial tribunal if he or she feels that need of doing the same as per the facts and circumstances of the case. Sometime it may happen कि कुछ इशू ऐसा है कि जिसमें लेबर कमिश्नर कुछ हेल्प नहीं कर सकते, या फिर ऐसा उनको लग रहा है कि ये जो केस है that will like directly go to the labor court, उसको सीधा वहां पे ही जाना चाहिए. So they will directly refer to you कि आप इंडस्ट्रियल ट्रिब्यूनल में जाओ या लेबर कोर्ट में जाओ. Right? Under ID Act, reference of dispute to the labor court, industrial tribunal, or the national tribunal only possible once they assume the nature of industrial dispute only. Then we can go there, right? Or else we cannot. And last, there are two type of dispute we have. One, that is individual dispute, and second we have industrial dispute. Common name individual, that means person, particular person will have the issue, kind of non-payment of salary, non-payment of gratuity, or not like giving the particular paid leaves on time or whatever. Company is not confirming after 240 days, right? Regularization of employee, yes, I can go. And resolved by the grievance redressal machinery within the company or under such act. That payment of wages, payment of gratuity, minimum wage, etc. That is individual dispute, right? And next one, what are the industrial dispute? They are heard by the industrial tribunal. So industrial dispute are those which will have the matter of large group of people, like dispute for the leave and attendance policy of company. It is related to the large number of people instead of particular one individual, right? That will refer to the industrial tribunal. Right? There is such exception above, like section 2 subsection A of the ID Act, that retrenchment, dismissal of employee, termination of workman gives the right to the workman to approach labor court or tribunal directly. In that case, we will not go to the labor commissioner, or you can say conciliation officer. In this case of retrenchment, like dismissal of employee, termination of employee workman, under this, then we can directly go to the labor court or tribunal. These are the rights that every employee have, right? Okay. And Tribunals handle a lot of technical work to the wages, hours of work, leave, bonus, discipline, retrenchment, which is specified into third schedule of the ID Act that we have to refer. In second part of this session, we will refer this. So labor court will have some authority to handle some situation, such issues, and tribunal again will handle this kind of issues. मतलब लेबर कोर्ट के पास कुछ इश्यूज आएंगे जो हैंडल करेंगे एंड कुछ इश्यू आएंगे जो डिसिप्लिन है, रिट्रेंचमेंट है, बोनस वगैरह, पूरे कंपनी को प्रॉब्लम है, पूरे एम्प्लॉय को सभी को प्रॉब्लम है. इन दैट केस as per the third schedule of the ID Act, that will directly come to the industrial tribunal. Right? So, okay. Till now, now we have 5 minute time for the question answer. If anybody has any question,